Thank you very much. And thank you to everyone who's joining us live and everyone who's able to participate via an online means, whether recorded or live in the future. Our panel today is the nuts and bolts of commencing a commercial receivership case. And this is the first in a four-part series that are designed to help introduce you to experts and to provide information on initiation of a receivership and on how it's administered and ultimately closed. We'd like to also point out today that our panel is sponsored by several generous sponsors, and it's been facilitated by Financial Poise, which is affiliated with Daily DAC, the leading insolvency news source, I think, or one of the leading insolvency news sources available in the U.S. Our sponsors today are Mood, an online cannabis dispensary. Our other sponsors include Type to Learn, which is an educational platform, and Max Asset, which is an industry professional organization dealing with liquidating assets for bankruptcy trustees, receivers, and assignees. My name's Eric Peterson. I'm an attorney with Spencer Fang, and I'd like to give you just a brief overview of what we're going to be talking about today and in future seminars. So today's seminar is about how to initiate a receivership. And by way of background, a receivership is a process by which an estate is created. It predates the bankruptcy code. It's a creature of common law. And to understand a receivership means one needs a basic understanding of what an estate is. An estate is essentially, it's kind of like a corporation. It's judicially created, and it is something by virtue of court order, property rights are inserted. They're inserted and they're placed under the control of a receiver. To help me with this seminar today, we've got an outstanding faculty. Matthew Brash with New Point Advisors and Mark Silverman of Lock Lord. These two are a couple of the leading practitioners in this area in the United States. And honestly, if you've ever have a bet the company or high leverage situation, you're going to want to talk to these folks. Their bios can be found at the end of the materials here. Bob Hammocky couldn't join us today. He was called away to trial, but he will join us for future panels. And when I say they're bet the company and they're the right kinds of professionals, I really do mean that. Mark Silverman, and you can check out his bio, has expertise. His job is to collect money and maximize recovery for his clients. And he does that by thinking many steps ahead in the process and by evaluating whether receivership or some other mode of collection is appropriate and what combination. And with that kind of intuition and knowledge and experience, he helps his clients develop what is the best possible option for the legal process, pursuant to which you will end up maximizing value. Matthew Brash of New Point Advisors is similar. Although Mark and I, both lawyers, we talk about what other people should do. Matthew is the guy who actually does it. He's the receiver. He's the head of the New Point Advisors Corporation group that deals in receiverships and other types of fiduciary relationships. And he's experienced in not only administering and acting as a receiver, but in finding value and in unlocking value. And so we're very fortunate to have both of them here with us to talk about the strategic considerations and the process that goes into initiating a receivership case. During this panel, we'll discuss the decision-making process that precedes the initiation of the receivership case. Receivership isn't always the right answer. There are pros and cons that derive from legal process, the experience of the court you might be in front of, the location and type of assets, bonds, and the litigiousness of the parties, among other things. And so those factors all weigh in to whether a receiver is an appropriate vehicle for a proceeding, or whether some other proceeding makes the most sense. Our future episodes in this series are going to be how to administer a receivership once you've started one, how to conduct asset sales in a receivership, and how to conclude the receivership, which is nearly as important as how to begin it. In order to get to the meat of this discussion, excuse me while my PowerPoint goes back and forth, I'd like to start off with talking about a decision tree. So when one considers initiating a receivership case, there's a multiplicity of factors, and it is a little bit of a chess game if there is a litigiousness aspect to it. Now, there are many receiverships that proceed by consent and cooperation, and those are always welcome. But when you initiate a receivership, it's probably important to understand what can go wrong and what kind of issues might arise. And so a decision tree on what's most efficient, what's going to be most effective, and what will provide the most value to the parties is important. And for that, I'd like to turn over to Mark for a moment to kind of talk about what kinds of information, what kinds of research, and what kinds of background he would need in order to decide and evaluate whether a receivership is the superior or one part of a process for whether collection or a partnership dispute or some other kind of circumstance.
Yeah, understanding the state where you're going to be litigating is of critical import. And the reason is there are certain states that have uniform receivership acts in place, and there are other states where this is really just a construct of common law, or maybe there's some state law corollaries, or you might be dealing with the federal rules extracted into a state court process. And so really understanding the law of the state in which you intend to proceed is going to be the most critical step. The other thing to think through is what potential defenses the borrower may have to having a receiver put in. So receivership can be deemed a quote drastic remedy because in effect you're displacing the existing ownership, management, leadership of a company and or taking away real estate and putting it into the hands of a receiver to manage the rents and profits, et cetera, of the property. And so those courts have generally held are drastic remedies. So you need to come loaded for bear in states where that's required. I sit in Illinois, I sit in Chicago, practice in Illinois. Under the Illinois mortgage foreclosure law, the bar to getting a real estate-based receiver is fairly low. There's a fairly low bar to entry. That said, you move several states over, and that bar to entry can be a lot higher. You need to perhaps show fraud, or show some type of misappropriation of rent, or show some life safety issues and damage to the property that can't otherwise be handled or dispensed by the current ownership. And so again, back to your decision tree, consulting counsel at the outset to make the determination as to what the state law provides. That's step one. Step two, read your documents. Your documents are key. So if you're sitting in the shoes that I do, which is representing secured lenders in various states of distressed debt, there's going to be loan documents that govern your relationship with your borrower. Those loan documents are going to spell out what your rights and remedies are upon the occurrence and during the continuation of an event of default. And so in that vein, there's typically a spot about receiverships. And in a non-recourse carve-out real estate loan, upon the occurrence and during the continuation of an event of default, at lender's request, they can seek the appointment of a receiver or be placed as mortgagee in possession. For non-real estate debt, there may also be an obligation for you to be able to put in a receiver to control and operate the company. But understanding and knowing what your remedies are pursuant to your documents is going to make things a lot easier. Your attorneys can help you with that. And also if you have line of business folks that deal with this regularly, so from workout groups, special assets groups, whatever it might be, they're going to be pretty knowledgeable about that too.
So Mark,
Third,
if
go
I
ahead.
could just interject one thing that I think is of critical importance. There are, in my estimation, three types of states that deal with receivership when a receivership is concerned. There are states that have a very cursory, maybe very kind of amorphous statute. There are states that have a more robust statute. And then there are states that have what has now been adopted in probably 14 different jurisdictions, which is a product of the Uniform Law Commission called the Uniform Commercial Real Estate Receivership Act. Can you kind of give a highlighted view about what the differences are and how that would affect your decision making if you've got a state that has limited receivership statutory guidance for courts versus a state that has maybe a more robust receivership statute?
So I'm a fan, assuming that the courts are generally aware of and deal with receivers with any regularity. I'm aware of states that allow you to choose your own adventure. I do think that having the ability to craft a really strongly worded receivership order, having the ability to put language in the order that gives you effectively the right to do what you need to do to process the asset and be able to get at the dollars a lot quicker are stronger. That being said, I love the certainty of a Uniform Receivership Act state. You know exactly what you're getting into, you know what you're allowed to do, you know what the receiver's allowed to do, and it's codified and spelled out. And so, for example, in Michigan and some of these other places where you know exactly what a receiver is allowed to do pursuant to statute, okay, we now know we can do this and we can't do that. So when it comes to selling through a receivership, it doesn't need to be motioned up, it can be just pursuant to statute. And that's a very helpful thing. And so by contrast, in Illinois, we have to cobble together several sections of the Illinois mortgage foreclosure law or other sections of the federal rules in order to effectuate a receiver sale and then get title to insure it. And so it's all doable, but it requires judicial assistance and it requires a little bit of creative reading in order to get to that conclusion. So that's how I typically would advise in all of these various different regions.
Let me ask Matt. Matt, you're the receiver, so you're the one who's ultimately responsible for what happens. What's your preference in terms of statutory guidance, and how does that affect your evaluation of whether a receivership is the right course?
I mean, I'm sort of a bias in these situations. I think if there are creditors or third parties that are considering a receivership, usually you should be starting to push the buttons and pull the levers to implement and commence that receivership. Obviously, jurisdiction and where it takes place is, important. Some jurisdictions have their own standing orders of what a receiver can and can't do. The state of Illinois, as we've said, it has the Illinois mortgage foreclosure law on a real estate type basis. So in getting involved in these situations, you really got to lay out not just the jurisdiction or venue, but what is, and I know we'll get into this later, but what is, the nature of the business? What's the nature of the real estate? What is it that we are going to be, what's the objective here? Is it just to preserve and secure the collateral? Is it to operate? And before I take an engagement, I'm doing some research on that borrower, on that company, just to kind of see and understand what it is that's going on or expectations. I mean, believe it or not, there's been several times in the last couple of years where I've been appointed receiver on cases where the borrower's in jail or the borrower perhaps is deceased. So there are several situations and issues that come up to really make sure that when the order to appoint the receiver is entered, you're really hitting the ground running from day one. So kind of piggybacking off of what Mark said, the whole legal view of things, the jurisdiction, the loan documents, everything that kind of comes into play to determine that jurisdiction or venue and what you're going to do and how you're going to do it. You've got this added layer of what that venue jurisdiction will permit you to do as a receiver. And one thing that always kind of gets under my skin is, jurisdictions and courts that every time you sneeze, you have to come back and ask for permission to do so. So being able to measure twice, cut once, in these different type of receivership scenarios helps the receiver, helps the secured parties, key stakeholders, get a real understanding of what needs to be done from the get-go. And even before the receivership, I always encourage lenders, third-party stakeholders, attorneys to contact me if they're interested in a receivership and talk one through. We have one potentially in Las Vegas where I've been on the phone with the lender and their attorneys for the last 2 weeks, kind of to craft out and determine what's the best venue, what's the best way to get this through, because the last thing you want is to hit a bunch of roadblocks and landmines that's going to interrupt the ability of the receiver to do their job.
So I know for sure that what you just said about thinking this through is music to Mark's ears, because I think that is where he probably, or his colleagues will tell you, he excels. Mark, when you're preparing this analysis, what is the information that you're taking in to make the decision about creditors, about litigiousness, budget, all of these things? What are you taking in before you can give a hard recommendation on receiver or some other process?
Absolutely. If it's a operating business, that's really important to understand what cash is actually coming in and what a receiver can actually do to either maximize that or improve that during the pendency of the litigation. So whether it's a foreclosure, an asset sale, whatever it looks like, we need to understand that either this asset can be turned around or losses can be mitigated. And so, for example, if you have an occupancy issue and you just can't lease up an office tower, I don't know very many receivers now that can come in and turn that around. There's not enough office tenants to be able to turn around a distressed office in a bad location. And so you may instead be focused on loss preservation. So what can we do to prevent there from being further losses to this property? And so that's a very different analysis and a very different expense ratio and expense burden than if you can take a strip mall and you can add a couple of credit tenants, long-term leases, and you can turn a 74% occupancy into 100% occupancy by getting AT&T to come in and take a vacant space. That's a very different receivership, and the expense burden on the lender is very different as well. And so when we talk, and when Matt was talking about kind of having a bespoke understanding of each situation, that's spot on. We will talk our clients out from us having worked many times because it just doesn't make sense. And so we may not want to file suit. We may not want to put in a receiver because they're already trapping cash and a receiver is not going to really add any additional benefit other than just to create expense. Then you have strategic receiverships where you put in a receiver to accomplish a goal, whether that's to help restructure a business that's operating or to develop a property. And so to get a property sold from through the courts, and that's another good way. Another reason to put in a receiver is if it's a property that has some hair on it that a lender may not be comfortable taking into REO or taking back onto their books, having a receiver sell the property jumps the lender in line. And the best example I can give of that is maybe a decade ago, I did an airport, a towerless airport for a bank. There is no chance that a bank is going to own a towerless airport in the middle of a cornfield. The liability on that is massive. The operations on that are massive, and it requires FAA approvals, which banks aren't going to be able to get. And so the options were run a structured sale and get it sold to a bona fide third-party purchaser vis-a-vis a receiver. That's what had to happen in that circumstance. Sure, maybe there were some other solutions or other strategies, but all of them involved potential risk that the bank would have to credit bid and own that asset. And that's simply something that couldn't happen. Dry cleaners on the smaller scale, that's another one where there's potential liability. I know Matt can probably run through a laundry list of other quote unquote dangerous assets, dangerous types of business that banks and other lenders just can't have any part of. And so making sure that I have those discussions with my client up front, but also talk to the receiver and get an understanding as to what the receiver is capable of. So just to give you another example and another consideration, if we're working on a distressed hotel, for example, and my client gives me a receiver, a well-known receiver, but that receiver has never done a hotel before, and it's the hotel that we're talking about is franchised and branded and has issues with the flag, I may politely push back and say, hey, I like that receiver a lot. I think they do excellent work. This is a hotel. We need to go to a hotel and hospitality receivership that has significant experience in dealing with XYZ flag franchise and knows the ins and outs of how to manage that computer system, reservation system, and deal with the comfort letters and all the other issues that pop up with the hotel. So those go into the analysis.
I appreciate that it is critical. You're both right on, in my experience at least, that you have to tailor your approach case by case. And honestly, I sit and I look, and if I were a law school professor and I wanted to create a complex fact scenario and ask a receivership question, I would choose the cannabis industry because it gives you all of the potential problems. And I wanted to tick through those very quickly because I think that they also can be very important in making the decision. For example, in a cannabis business, because of the federal taxation issues, the operation is frequently splintered into multiple pieces. One entity will own the real estate, and another entity will employ the employees, and a third one hires the security company, and a fourth one sells cannabis, and they all exist in this same building because they're trying to figure out a way to be able to claim at least some level of business write-offs for their taxable expenses. Otherwise, they have to pay tax on every dollar. But that introduces things that may come up in other scenarios, such as corporate structure. Even in a hotel, you can have different entities owning different aspects. Maybe one entity operates the bar and another one operates the rooms, or they have different types of creditors. Some hotels buy equipment on credit, others lease everything down to the dishes. How do those things factor in, and considering the defaults, into, is the receiver the best situation? Or if you've got arrears, you've got defaults, you've got a complex set of creditors, maybe you have litigious parties, is there a better way than a receivership to corral all those issues into one forum where the debtor doesn't want to file a bankruptcy case?
So, Eric, I'll chime in for a second here. From the receiver side of things, being a financial consultant and advisor, and I know Mark does this because Mark and I talk about this, is when we get the call, the discussion is not just, okay, if they're thinking receivership, we'll talk about that, but let's also talk through other scenarios and options that are out there, because it's our job, and your job as well, Eric, to walk through the client of all the different opportunities, the pros and cons, the risks, the rewards of going through each of those different type of scenarios. For example, let's take a construction company that I'm the limited receiver over, not the traditional full receiver over, because that construction company has a disadvantaged business enterprise certification. And if I come in as the receiver, perhaps there is a chance that that certification is going to be lost if I'm the full-blown receiver. And so we decide to keep the owner in place as the operator of the business, but me as the basically in control of all. It's like an interim CFO, but with court backing. So, you can't pass go, can't collect $200 without coming to me or asking for it. All monies flow through, and all business decisions from a financial standpoint flow through me. The risks involved in it as well. The cost, as Mark was saying earlier, can be enormous on situations where, maybe an Article 9 might be the most efficient way to do things. But you mentioned a very important, powerful thing too, Eric, which is how litigious is the situation going to get? I know that as a receiver, getting a judge's signature or stamp on court orders as it relates to various action items that a receiver or perhaps a stakeholder does makes you sleep a little bit better at night, knowing that there isn't that backing of a court order on how you are pursuing or doing things. So, for example, in your hotel situation with various entities, that's a lot to navigate. If you're just the receiver of the hotel, but the bar or restaurant is a completely different entity, but it's also owned by, they have the shared principles of it, that also can get tricky. So there's a lot of things that you have to walk through and a lot of decisions that have to be made. And like I said, there is risk reward for several different areas, and walking through whether is it pushing them into a bankruptcy the right way? Is it receivership? Is it a limited receivership? Is it an ABC? Is it an Article 9? There's so many different variables and costs associated with each one. And, I too am someone that talked myself out of getting engagements at times because, we determined that the most efficient, effective route is not the receivership or ABC route, but it might be an Article 9 or it might be some other type of scenario.
And there's one other factor that I think is missed by a lot of folks, and that's the taxes. There is guidance from the IRS. But it's not widely known. A receiver can actually incur personal liability in circumstances where there are unpaid taxes and that the receiver makes distributions to whatever it makes distributions to without taking care of the taxes first. And can you kind of talk about where does that weigh in? how do you kind of address that in a circumstance where a receivership's absolutely necessary? And, you know, you're going to have to pay as you go for your administrative, your receivership expenses. But there's this albatross sitting out there of unpaid taxes. And, you know, you're going to, at the end of this, know you're going to be asked to distribute cash after you sell a property.
Yeah, I think that not only just the tax standpoint, whether it's your income or property or trust fund taxes, similar situation, and this kind of goes back to our previous slide discussion about whether to take a case as a receiver or not. You know, I got to make a decision, as do other receivers. You know, you get a call from an Eric or a Mark saying, "Hey, we've got this receivership for you. It's very interesting," and my ears always perk up with that because I love hair on things. I love when things are tricky. I like things that are complicated because that, you know, something I like to dig my teeth into and go after. But at the same time, I got to sometimes put the brakes on my own ambitions and, you know, aggressiveness when there's a situation of, oh, they haven't made payroll and they're still operating, or they haven't paid taxes, or what's the situation with their income or property taxes. Like, that is something that keeps me up at night on current receiverships I have. You know, there are several times on 2 engagements I have right now where, you know, we have barely made payroll, and I've told, you know, you got to go to a bank or a key stakeholder, usually the petitioning party, saying, listen, if we're going to do this and take on an operating receivership, or even in some circumstances, a commercial real estate receivership, if there are insufficient funds to pay payroll taxes, or other taxes, you need to come up with that money, and you need to be able to fund that, because I'm not going to take that personally if they're not paid. So that's another decision that weighs in on the attorney representing the creditor, excuse me, secure creditor, or the bank, by whether they want to, you know, if they're going to be okay fronting that expense. And there are several times when you go into these situations where, you know, whether it's a bank or it's, you know, a business divorce, or there's shareholders that are trying to determine, you know, where the money is going and why they're not getting distributions, and all of a sudden things are kind of fall apart. Do I want to stick my nose in that business and, you know, really risk my own neck if there isn't the ability to fund payroll, fund taxes, and other critical priority expenses? Otherwise, I'm shutting the business down, I'm closing, I'm sending everybody home, and that's kind of where things head with it.
Right.
By
So
providing your Warren Act notices though first, right, Matt?
very good.
Of course.
Good catch.
I did want to mention one thing on that, Eric. So
Mhm.
the other piece of this puzzle is that some receivers and some receiverships, mostly in the city and municipality context, that have been appointed for life safety issues, they get compensated through the issuance of receiver certificates, which create a prior perfected senior lien on the property that's senior to even mortgage debt. So even if you have a prior perfected mortgage loan that's technically ahead of you, your receiver liens will jump them. What it won't jump is taxes. So if you're going to step in as a receiver on the behalf of municipality, and you're looking down the barrel of a multi-million-dollar tax deficit on an office tower in the city of Chicago, that may not be an engagement that you want to take, because no matter what your receiver certificates are issued for, the taxes need to get paid. So it's just another consideration to keep in mind as you're advising clients, whether they're receivers or whether they're secured lenders.
So let's assume that you have decided receivership is the way to go. Mark, what does the case look like as you initiate it? What do you have to file? What do you have to prepare? How quick do you get in to see the judge?
So I'll give you 2 examples. So in a state that is a judicial foreclosure state, you file a judicial foreclosure complaint with all of the ancillary documents. You get that served, and typically either same day or day after, you then file a motion or petition to appoint receiver, depending on the state in which you sit. That petition to appoint receiver is typically verified in some way, shape, or form. And by verified, I mean there's typically a declaration of the lender stating that there's a default and attesting to a lot of the underlying facts. That's a judicial state. In a non-judicial state, you may file a complaint or petition to appoint a receiver. Sometimes it's advisable to file a judicial foreclosure count in that state at the same time, just to avoid any one action rule issues or avoid any other items that may come up. But down the road, you may ask the court and ask the receiver to discharge or dismiss that foreclosure count so that you can then take it through a trustee sale in a non-judicial forum. So those are really the two ways that those cases get kicked off. In some of the Uniform Commercial Receivership Act states, you can just file a complaint for the appointment of a receiver. It doesn't seem to be the norm, and there does seem to be a requirement in most of those jurisdictions to include some other cause of action with your receivership. But I view best practice as including as much as you can in your complaint and walking back what you have to at a later date.
And you're filing it, who are you giving notice to? Because potentially there's a lot of people affected by this appointment if it occurs.
So on a real estate side, we order minutes of foreclosure, which will then, or foreclosure commitments, state specific. It will give you a list of all the necessary parties and all of the permissive parties. Our view is you give notice to anyone and everyone, you over notify so that there is no concern down the road. On an operating business side, we typically give notice to any interested parties, and that's typically done through a letter after the receiver is appointed. But if there's, if there's thousands of members of an LLC, they may ultimately get notice, but they're not going to get served unless there's some legal requirement to do so.
All right, so let's assume you've done that. The due process components of this are satisfied. You've given the appropriate notice. You're going in now early in the case to have a receiver appointed. You've filed your motion. What are you submitting to the judge? And in specific, what does your appointment order look like?
Appointment order is the Bible. It's the absolute most important document that you're going to submit to the court. The motion is important, and if you've got fraud or misdeeds or other bad acts, making sure that you have a really well-formed motion petition is going to be important. But boy, that order is critical. And in that order, you want to make sure that you've really thought through all of the various issues for your asset class. So take an office tower, for example. As Matt said early on in the presentation, the last thing that a receiver wants to do is come running into court every time that they sneeze. So in an office where you could potentially have tenants that are renting very small inline spaces and might be very fluid to come in and sublease, you don't want to have to come running into court every time you need to sign up a lease. So you include language in the order that states that up to X square foot and up to X lease term were permitted as the receiver to enter into and effectuate these leases. And it's stamped and signed by the judge. And so you're good to go. Same is true for expenses. So if you know that there's a significant amount of deferred maintenance on an industrial site, for example, then you may not want to include a small cap on what's permitted to be expended by the receiver without further court approval. So in a typical case, we might make it 10 to 50 grand, depending on the lender, as to what the receiver can expend on breaks and things of that nature without coming to court. For a larger project where you know that there's a $160,000 roof repair, that you know that you've got a $200,000 HVAC repair, and the lender's already approved these expenses, you might give the receiver in the order a little bit more latitude to do this so that you're not consistently running to and from court to add this. The other piece is you want to address how pre-receivership AR is going to get handled, and it's really going to be state specific and case by case. In some states, you don't have to pay any pre-receivership AR. In other states, you do. Or it's a jump ball and it's a question. But I'd like language in my orders that say what we're permitted to do so that we don't have to go through and brief it. The other thing to think through is real estate tax appeals and things that deal with, that could potentially run with the land. So if some firm has done real estate tax appeal work for a building, and you as the receiver get the benefit of that tax break, tax reduction during the receivership, who pays the law firm even if the work was done pre-receivership? And again, you can't game all of this out in the appointing order, but the more of these issues that you flag and that you attempt to resolve, the better. Last one, anything dealing with the franchise or flag, whether it's a restaurant, whether it's a hotel, any of those franchise issues, franchise fees, all of that needs to be baked into your order to ensure that you don't piss off the people that are giving you the opportunity to use their brand. Sure. I yield the floor.
So I understand if it's a bank or a lender in particular, all of these features of the order are absolutely critical. Matt, you're going to be put into place. You're an arm of the court. What do you want to see in this order?
Everything under the moon and sun. So, it's, again, it goes back to what is the objective here from an operational standpoint. if we're talking about a traditional full-blown receivership where the receiver, myself, and others are taking full control in operations, financial as well, of the business, we want immediate access and unfettered access to all books and records, whether electronic or not. We want all access to all bank accounts, cash equivalents, all financial institutions. We need to make sure that any asset, whether cash, equipment, machinery, inventory, vehicles, trademarks, those are all basically immediately directed into the receivership's possession. We also want language in there that basically states that a receiver can retain, legal counsel, can retain a broker, can ask to borrow money. Even though that those items are stated in an order, I take usually the precaution of, even though I have the ability to retain counsel or retain a broker or sell property or sell a business or liquidate assets, I'm able to go back and I still get the court to do another, we motion up the court and get them to approve whatever that item is going to be, just so that we can have a final order on it. But like I said, we want to make sure we have all documents, all codes, all security codes, keys to the premises, contact information of all the employees. We want to have customer lists, AR lists, contracts. I mean, you want to walk into that business or that piece of real estate knowing that you have a document in your hand that basically directs all personnel, all people involved, whether part of the ownership group or not, or management committee or not, that they have to turn everything over to you right away. Because the way I look at it is that party is also going to have counsel on their side. And they're going to look to poke holes into that order to say, well, you don't have to do this. You don't have to give him or her this because the order doesn't state it. So we want it to be pretty bulletproof as possible. And that's why it's extremely important to work with counsel for the petitioning party to craft and draft that order in a manner in which, you don't need to go back and ask for additional permission to do things. You're just doing it more as a courtesy and a precaution to the court.
So there are, in most states, I think, a couple of different, and this is kind of the beauty of receivership, different ways to tailor your receivership. And Mark's talked about that a little bit in specific circumstances that you find yourself. But on a kind of a broader level, a lot of states, and the nomenclature may change, but there's limited receivers, those who take control over just some subset of the assets. It may be a huge subset, it may be just books and records, but they're limited. And then there's a general receiver who takes control of effectively the management right of the company itself. In those two situations, how different is your order outside of just the simple, I'm going to attach an Exhibit A to my order that says, here are the assets that are placed into a limited receivership. Outside of that, kind of discrete definition of the assets, what else would you change if you were a limited versus a general receiver, and might a limited eventually become a general receiver?
Well, I know one thing, and Mark and I have always talked about this, is there's certain court and jurisdictions that they have a standard form order of what the receiver can and can't do. Let's take, for example, Cook County, Illinois, the mortgage foreclosure, mechanic lien, chancery department has a pretty standard order throughout the various calendars of what a receiver can and can't do. Like, for example, it's going to be very tricky to get a receiver to be able to sell real estate without a judgment, or without it becoming a private sale officer after that petitioning party creditor gets that judgment. Really it's, determining what is, as you said, Eric, what does the state allow? What does that particular jurisdiction county allow for a receiver to do or not to do? And, we try, and sometimes it's better to ask for forgiveness than permission. So there's times where we will go in with, full-blown orders of what we would like to accomplish with that receivership. And then sometimes the judges will dial it back a little bit because, either A, they're not as comfortable with that language because they've never done it before, or because that's just really the court's standing order of the way that they're going to handle that receivership. And it's, many times it's, all right, we'll come back, Mr. and Miss Receiver. If something does change and you see that we do need to go the route in which, you originally presented it, but I'm not going to allow it for right now. But as far as the state laws and everything, I think, from your perspective, Mark and Eric, I'd be more curious to hear about it from a legal standpoint.
From my standpoint, it's most critical in a limited receivership to understand what your rights and responsibilities are as the limited receiver. So for example, if there's taxes that are getting paid and they're getting paid at the parent company level or at the upstream non-receivership assets level, that needs to be stated in the order so that there's no question as to who's doing what. If the limited receiver is taking care of all of the books and records and is now maintaining all of the books and records, the limited receiver is going to have to share that information with the company so that they can fill out their own tax returns and that they can fill out their own information. So the receiver is not going to sign off on those tax returns. The receiver is not in that scenario. But if you don't have an order that clarifies that, you're going to end up with a lot of open questions come tax time. So that's a big piece of that puzzle. The other item is from a liability standpoint. On the slide, we have healthcare, we have senior care, et cetera. Some of those require very specific licenses in order to get paid. And so if you're coming into that scenario as a limited receiver because you cannot get licenses changed, that's important too. So under no circumstance would the receiver be doing any healthcare, any senior care work that would require them to be licensed. And therefore you have that limited receivership order that gives you cover. My personal preference in those scenarios is to find a receiver that's licensed and that has experience in handling those types of assets, because you then limit your potential downflow liability in that regard. But again, case by case, deal by deal, situation by situation specific. But those are good reasons why you just want to spell out what the receiver is responsible for in your limited order.
So, and thank you for mentioning those discrete items. Most states have separate statutes that deal with receivers. And I think what we're talking about in these separate statutes is something more akin to a general receiver over a senior care or a healthcare facility, certainly an insurance or utility. But it's interesting to hear, Mark, when you talk about the remaining potential to have a limited receiver appointed over the assets, a subsection of the assets of these types of industries. And I'm wondering if you've done that in the past, and if you have, did you get pushback from either the defendant or from a regulatory authority?
So we've not done it in the healthcare space, but we've done it in the specialty finance space, where the receiver was appointed to maintain and manage effectively charged off facilities from another lender. And in those situations, having someone come in with that specialized expertise, but not actually running the underlying company, which was no longer viable, that had a lot of merit and didn't require going through the ultimate relicensing process. And so it's akin to what we've just discussed, but it's a way to shift the value to a receiver and the potential value to a receiver while not necessarily saddling the receiver with all of the burdens of the company.
Now, and I want to shift a little bit back to the content of the appointment order. So for people who have done a lot of receivership, they're aware that these orders are 25, 30-page long orders with a great deal of detail and information in them. And the reason that that's important is not only so that the receiver has what he needs to, or she needs to, go around to the various stakeholders and to say, I have been authorized with this power, you should comply, otherwise the judge will have to, step in. The other part of it, however, is to protect the receiver. The receivers, generally speaking, protected in most states, whether at what level of immunity, it can vary. But the receiver is protected with some level of immunity so long as the receiver is acting within the scope of the appointment order. If an appointment order is deficient and doesn't cover things sufficiently, doesn't the receiver become exposed to a potential claim of kind of an ultra vires act, acting outside the appointment order, where they haven't been given the express authority that they may purport to exercise? And by way of example, I'll say, let's say you're appointed a receiver in a case and there is property in another state. Now, clearly, your state court has no jurisdiction to confer control over property situated outside the boundaries of the state. The court does have power over the parties in the case and can compel their cooperation. What do you do in that situation where you've got out-of-state property? And what do you do in the situation where the appointment order is less than clear or is less than thorough in terms of the various types of property you might exercise, or maybe even fails to identify whether you're displacing the board or the president? How do you correct or address those kind of loose ends that can crop up?
I would go back to the beginning. Where did you choose to file what venue? In the situation that you've described, Eric, I'm not sure that state court's your best place. I think at that point, to the extent that you can and that you can meet the jurisdictional requirements, you go to federal court. And the reason you go to federal court is because the federal equity receivership laws are very clear. And so you can then lodge your order in different states to then allow that state to take notice and effect that there's a federal equity receiver in place in jurisdiction X. And that's a much more efficient and effective approach than going state by state. Where this falls down is sometimes on the real estate front. And the reason why it falls down on the real estate front is because often state law is going to be more favorable for foreclosure and taking back of assets than federal law is going to be. And the state courts are generally a little more familiar with how to deal with a real estate receivership than others. But in the example of, let's say, an equipment leasing company where you've got equipment all over the country, and you can meet the jurisdictional hurdle, a federal equity receivership that allows you to go lodge that order and grab assets in different states, that's of huge value. And I know we're here to talk about state court receivership, so I apologize for taking us off topic, but to answer your question, that to me is the best approach.
I mean, I don't think it's off topic at all, Mark, because it's the truth. It's the answer. I mean, again, I know we're dealing with state receiverships here, but you really do have to go back to the beginning and understand where all the assets are, what the goals, objectives are, what needs to be done, and the pros and cons of doing federal, state, or the various different types of fiduciary roles that you can bring in a third party for. So there could be a whole webinar on when is federal right and when is state is right, and you could there's a lot to goes into both of those.
Well, and I definitely see your point in that a U.S. district court has a broader scope of influence than does a state court. But as you mentioned, sometimes you can't meet the jurisdictional requirements, or sometimes, for some other reason, the state court is the forum of choice. And in those instances, what we've at least had some success with is initiating ancillary receivership proceedings. So, for example, I'm involved in a case now where we have assets both in the U.S. and out of the U.S. And in so far as the assets in the U.S. are concerned, because it's a state court proceeding, we initiate ancillary receiverships in the states where the assets are, so that those courts can kind of monitor and direct and enforce the rights and duties and obligations. It does add some level of complexity, because now you're filing multiple lawsuits with multiple case numbers and multiple reporting requirements. But it is another alternative that might be considered. Matt, let me ask you something that I know is important. Now, you have never mentioned it to me. Other receivers have mentioned it to me. I'm sure it's important to you as well. And that is the budget, and how does the receiver get paid? And when does the receiver get paid?
Sure. So, there's obviously each receivership, as we've discussed during this webinar, there's different circumstances facing it. What is the goals and objectives? What is the fiduciary responsibilities of the receiver? Just like in any normal workout type scenario, you're going to be wanting to prepare, at least our office does at the very least, a 13-week cash flow model and budget, just to be able to get into feel and understanding of whether the business or the property can cash flow. Can it meet, its basic operational needs? And then is there going to be cash available with that business or with that real estate based on the rents that come in? From a net, proceeds standpoint, is there money to pay the receiver through that budget? Of course, we don't get paid as a receiver until we prepare usually a fee application. Usually those are attached as an exhibit to your receiver reports. The submittal of your receiver reports are done on various type basis. Sometimes they are after the immediate appointment of a receiver. They can be anywhere from 30 to 45 days. Sometimes they are 3 months. It just depends on the jurisdiction and what the order and what the court and what the receiver and parties agreed to. Usually on cases that are a little bit more sticky, I like to file a report within that first 30 to 45 day window, just because you really need to understand what is going on, what's going on with the cash, what's going on with the business, what fires need to be pulled, put out right away. So having that budget in place, accounting for all the operational expenses of the business, and taking into account the receiver's costs, perhaps the receiver's counsel or other professionals that you retain have to be included as well. And then, of course, going to the court and getting permission to do so. Now, as far as getting paid, usually what it is and what you're hoping for is that the business or the piece of real estate or whatever the receivership is, there is enough funds to pay for the receiver's fees and expenses and other professional fees and expenses that are incurred. If there are situations, and it does happen quite a bit, where there isn't enough funds to pay for the receiver fees and expenses and the receiver's professionals that they've hired, he or she has hired, as well as operating expenses that can't be covered, then usually you are directing the court to order the parties to pay. And sometimes it's usually the petitioning party that is put on the hook for that, because they are the ones that put the receiver in or petition the court to do so. There are other situations in which I become a receiver and the parties have agreed to split any excess costs or expenses incurred by the estate that the state doesn't have the financial ability to pay for. And usually when you get your receiver report in and the judge approves the fees, barring any objections to the fees, expenses, or the report, you get your order that approves the receiver's report, fees and expenses incurred in, and how that's going to be paid. If there is parties that are just going to refuse to pay, as Mark kind of said before, you issue yourself a receiver certificate and you basically attach it to the business and to who or the property or collateral. So when you go ahead or someone goes ahead and sells or liquidates it, the receiver certificate is going to basically be the superior first payment that's going to be made from the liquidation of those proceeds.
And I'll point out one thing, because I think Illinois deals with the receiver certificate process, and I suppose we could do that. There are other states, however, and I know my home state of Missouri is one of them, where the statute specifically provides that the costs of administration can operate as a surcharge to the collateral of any petitioning creditor and any creditor who consents to or benefits from the receiver's administration. The benefits from is a little bit trickier because that's a question of how do you measure benefit. But certainly if there is a secured creditor who doesn't object to the receivership, there is a reasonable chance that their collateral could also be surcharged. And I think that's kind of it's kind of a different way of dealing with the same concept of a receiver's certificate, as I understand it. Mark, I saw you nodding your head.
I agree.
So, once you're appointed, what do you have to do now? So now you're appointed. When the case was initiated, Mark gave notice to anyone who was, say, on title perhaps, or had a recorded interest. Who gets notice now? You've got a whole body of unsecured creditors and other stakeholders and all of these different folks. How do they get alerted that their rights may be administered in this case and that they have an opportunity to participate if they would like it?
So there's different scenarios for each type of receivership. And I think that, I've learned over my 15 years of now doing this and being a receiver in, I don't know, hundreds of cases that, each situation you have to be careful on providing certain notices and what notices need to be provided, not to be sneaky, but because you don't want to necessarily upset or get in the way of the operating business. So obviously, usually as a receiver, one of the first things I do is not only, you're notifying and going to the company and giving them that court order that you've been appointed, but you're also reaching out to, like, for example, on a let's say pieces of real estate. I'm usually notifying the local municipality, whether it's the buildings department, the mayor, the utility department, anyone that basically needs to know that, from now on, myself or other receivers, he or she is now basically the one that needs to be directed to any issues or complaints or situations involving that piece of real estate. I usually also let local authorities like the fire departments or police know and give them a copy of the order, make sure they have copies of the keys, for that piece of real estate, or they're located in the box on site for them to get access to. As far as other creditors and letting them know what's going on, each situation is different. I know that the Illinois mortgage foreclosure law requires you to provide notice within 21 days to all tenants of the receivership. So you definitely need to do that. But from a business standpoint, again, not to be sneaky, but, letting people know, and it depends on each situation. If it's a traditional receivership, I'm usually letting everybody know that, there is someone else that is now in charge, that, whatever situation that we're having beforehand, we're trying to change it up and restructure, reorganize the business. But on a limited receivership basis, if I am only limited to the financial part of the business, and there's certain certifications that are involved, let's take like a bar restaurant, for example. There is a liquor license. You got to be careful with that as well, because could you risk losing that liquor license with the receiver being in place? So there's different ways and different things you need to look at. But that's also why, as a receiver, I look to hire legal counsel, because they're the ones sitting on my right shoulder right here, whispering in my ear, telling me what I should and shouldn't be doing in certain situations. So that's important.
And I think that is a nice way to round out what we've been discussing, especially from the beginning, which is you have to tailor your approach in a receivership. You have to think through the implications of the case before you get a receiver appointed. And that analysis at the outset is going to inform how and where you begin the case. What is going to be in your order and what's going to be excluded from your order. Sorry. And it's also going to deal with kind of questions of case administration and other aspects of this. I apologize that my phone's ringing. But I appreciate you both participating today. If there are questions that folks would like to submit, we encourage you to do so. The contact information on our panelists is included in the materials. I'm sure they would welcome input and questions. We also are going to have upcoming seminars next week and the following 2 weeks after that are going to deal with how you administer the receivership, how you sell property, and how you conclude a receivership. And we look forward to presenting those in the future. But for now, thank you so much. Thank you for all who participated. And thank you, Mark, and thank you, Matt, the panelists today, for an outstanding presentation.
Thank you, Eric, and thank you, Financial Poise, for helping us or allowing us to be on this webinar.
Very good.
Ditto. Thanks, guys. Take care.